Welcome back, deep divers. Today we're plunging into a really crucial corner of patent law, one that can genuinely make or break an invention's journey onto the global stage.
That's right.
We're continuing our exploration of the Manual of Patent Examining Procedure, the MPEP, looking specifically at Chapter 200. That's the one covering types and status of application, benefit, and priority claims. And our mission today is to really unpack MPP Section 216, Entitlement to Priority.
Yeah, this is a big one.
It is. This section explains how a U.S. patent application can claim the benefit of an earlier filing date from an application filed, somewhere else in a foreign country. It sounds technical, and, well, it is. But understanding this is honestly a game changer for protecting your intellectual property worldwide.
Absolutely. Think about our inventor, Dr. Sharma, with her battery tech. She filed first in Germany.
Right.
Now she wants that U.S. patent. This section is how she links that German date to her U.S. application.
Exactly. So let's dig in here. Why is that earlier filing date so powerful? And, what does properly claiming it really do for someone like Dr. Sharma?
Well, the power, it's huge. People sometimes call it a time machine for your invention.
A time machine, I like it.
Yeah, because when a U.S. application successfully claims that foreign date, it's treated for certain key things as if it were filed back then.
Right.
And strategically, that's vital. It shields your invention from prior art, disclosures or publications that came out after your foreign filing, but before your U.S. one.
Ah, I see. So that foreign priority date becomes your shield against anything that popped up in between.
Precisely. Without it, something published just a day after your foreign filing could potentially knock out your U.S. claims.
Wow. Okay. So it's critical. How carefully does the USPTO check these claims right at the start? Does an examiner immediately go through the whole foreign application with a fine-tooth comb?
It's actually kind of interesting. They use a tiered approach. Yeah. So initially, the examiners generally just do a review of the certified copies for obvious formal defects.
Okay, like what? Missing signatures, wrong dates.
Exactly. The easy-to-spot stuff. They also confirm consistency with the data supplied, basically making sure the country, date, application number you listed matches the document.
Right.
They're not doing a deep, substantive dive into the content at that first pass. It's more of a procedural check.
Okay, that makes sense. Saves time if everything looks okay on the surface. But when does the examiner decide, okay, now I need to go deeper? When do they do that substantive determination about whether you really deserve that foreign date?
Yeah, that's the key question, isn't it? And PAPI-PEA Section 216 is clear. Those substantive determinations, the really detailed look, are only made when necessary for patentability.
Necessary for patentability. What does that mean in practice?
It means the examiner only digs deep if that priority claim actually matters for whether the invention gets patented. If there's no prior art anywhere near your filing dates, for example, then the priority claim might just be noted without that intense scrutiny.
Okay, here's where the rubber meets the road then. Could you give us some specific examples? When does this detailed review become absolutely essential?
Sure. Probably the most common one is when intervening prior art falls between the foreign filing date and the U.S. filing date.
Like the scenario we mentioned earlier.
Exactly. Let's say Dr. Sharma filed in Germany on January 1st. A competitor publishes something similar on March 1st.
Okay.
Dr. Sharma files her U.S. application on May 1st. That March 1st publication, that's intervening prior art.
Got it.
To get her patent, she needs to successfully claim that January 1st German date to overcome the March 1st publication. Without it, she's potentially blocked.
It makes perfect sense. Any other big triggers?
Yeah, another one is when an interference is being considered. Now, interferences are less common under the current first inventor to file system, but they used to be contests to decide who invented first. And even now, establishing that earliest effective filing date via foreign priority is still critical for navigating prior art disputes and proving who has the rights.
So in those critical situations, like with intervening art, if the examiner says, nope, this reference blocks your claim, what can the applicant do? How do they fight to keep that earlier date?
Well, they have a clear path. MPE Section 216 says they can respond. They can submit the certified copy of the foreign application, provide a translation if required, or they can argue against the rejection.
Argue how?
By showing how the foreign application does actually support the claims that were rejected. Pointing to specific paragraphs, figures, proving that every part of the invention claimed was already described back then.
Okay.
If they succeed, that troublesome reference is basically removed as prior art against those claims. It's their chance to prove entitlement.
You mentioned translations again there. This seems like a detail that can easily trip people up, especially if the first filing wasn't in English, like Dr. Sharma's German one. How vital are these?
Oh, incredibly vital. You really can't overstate their importance for non-English applications.
Okay.
So when the foreign application isn't in English, the rules say the certified copy must be accompanied by a statement that the translation is accurate.
A statement of accuracy.
Yes. And it's not just like a good idea, it's a strict requirement. Without that statement, the examiner basically can't rely on the translation to see if the foreign document supports the claims.
Wow. So what if you provide the translation, but you forget that statement? What's the actual consequence? Does it really matter?
It absolutely matters. The consequence is pretty severe.
Yeah.
Applicants cannot rely on the foreign priority date to overcome references without that statement.
So back to Dr. Sharma.
Right. Examiner finds prior art between her German and U.S. states. She gives them the certified German copy and an English translation, but oops, no accuracy statement. She might just lose the ability to use her January 1st date. The prior art could suddenly become a valid rejection. I mean, I've seen cases get held up for months, costing a lot in fees just to fix that one missing statement. It's a small thing procedurally, but it can have a huge impact.
Yikes. Okay, lesson learned there.
Yep.
So is priority always an all or nothing thing for the whole application? Or can it be more granular?
Much more granular, actually. That's another key point in Section 216. It explicitly says that entitlement to priority may apply to some claims but not others. Patent examination is very claim-focused, so maybe Dr. Sharma's German application fully described her core battery chemistry.
Right.
But her later U.S. application added claims for a new cooling system she developed after the German filing.
Oh, I see.
The chemistry claims might get the German priority date, but the cooling system claims, they might only get the U.S. filing date because they weren't fully disclosed back in Germany. The examiner checks each claim individually against the foreign document. And it gets even more complex. Applicants may rely on multiple foreign applications with different priority dates.
Multiple. How does that work?
Well, maybe Dr. Sharma filed a quick provisional in the UK first, then the more detailed German application, then the U.S. application building on both.
Okay.
She could potentially claim priority to both the UK and German applications for different features described in each. It requires careful tracking and clear claims.
That does sound complex.
Yeah.
Are there any particular quirks with foreign filing systems that tend to cause problems when claiming U.S. priority? Things people should watch out for?
Yes, definitely. There are nuances. For example, the MPP mentions United Kingdom provisional specifications.
Okay, what about them?
Sometimes they might lack complete disclosure under U.S. standards. The U.S. requires a pretty high level of detail enough for someone skilled in the field to make and use the invention. A UK provisional might sometimes be more conceptual.
So it might not be detailed enough.
Exactly. If Dr. Sharma's UK provisional was too brief, she might need to rely on a later, more complete specification filed in the UK to get the necessary support for U.S. priority. You have to meet the U.S. disclosure standard with the foreign document you're relying on.
That's a really important point. What else?
Another potential issue is when the foreign application was filed in the name of an assignee or legal representative rather than the inventor.
Like the company name instead of Dr. Sharma's name.
Precisely. Some countries allow that. But the U.S. system is very focused on identifying the actual inventor, so any discrepancies like that must be resolved before priority can be granted.
How do you resolve them?
Usually through documentation showing the chain of title, assignments, things like that, to make sure the U.S. application correctly lists the inventors and the applicant has the right to claim priority based on that foreign filing. It's about aligning ownership and inventorship properly.
Okay, a lot of potential pitfalls there. But what if you try your best, you go through the whole process, and then later, maybe even years later, you realize there's a mistake, an incorrect date, or you just flat out forgot to make the priority claim? Is it too late, or are you just out of luck?
It's a common worry. But thankfully, no, not necessarily out of luck. MPEP Section 216 does provide ways to fix things. While the deadlines for claiming priority are generally strict, the USPTO allows delayed claims to be accepted under certain conditions.
Okay, what kind of conditions? Is it just paying a fee?
Well, the fee is usually part of it, yes, but it's not automatic. The key is often demonstrating that the delay was unintentional.
Unintentional? How do you prove that?
You typically have to file a petition with the required fee and include a statement explaining why the claim was missed or delayed and attesting that it wasn't a deliberate choice. It's about showing it was a genuine oversight, not strategic waiting.
Right, good faith. And what if the patent has already issued with the mistake? Can you fix a priority claim after the patent is granted?
Yes, even then there are options. For simpler errors like a typo in a date, you might be able to use a certificate of correction.
Okay.
But if the error is more fundamental, if correcting the priority claim could actually affect whether the claims are patentable, maybe it brings new prior art into play, then you'd likely need to file a reissue application.
A reissue, what's that involve?
It's basically asking the USPTO to re-examine the patent in light of the correction. It's a more involved process, but it allows for correcting those more significant errors affecting patentability, ensuring the final patent is valid with the correct priority information.
Can you give us a quick example of how a defect might be cured? Maybe relating back to Dr. Sharma.
Sure. Let's say she filed a U.S. continuation application, one that builds on an earlier U.S. application, and accidentally forgot to restate the claim to her German priority in that continuation.
Okay.
But crucially, her earlier U.S. parent application already contained the certified copy of the German document.
So the document was already at the USPTO.
Exactly. In that kind of scenario, it might be relatively straightforward to cure the defect in the continuation by filing a petition, pointing out the certified copy was already on file, the core information was there.
That makes sense.
Of course, in other cases, as we said, entitlement to priority must be established claim by claim, which might require a much more detailed argument showing support for each specific claim in that foreign document.
So wrapping this all up, what's the really crucial takeaway for you, our listener, from this whole deep dive into MPP Section 216?
Well, I think the main thing is that understanding Section 216 is just vital if you're dealing with international patents. Leveraging that foreign filing date, it's an incredibly powerful tool. It can shield you from prior art, strengthen your position.
Right.
But, and this is the big but, it comes with very precise rules. You need the right documents, certified translations with accuracy statements, meticulous proof that your foreign application supports your U.S. claims, often claim by claim.
Yeah.
Getting those details wrong isn't just a procedural hiccup. It can mean losing that valuable earlier date, which could potentially sink your whole U.S. patent application. It really underscores how these procedures are the bedrock of strong global IP protection.
Absolutely. This deep dive really shows that, yeah, the devil is definitely in the details in patent law. Knowing these specific procedures in Section 216 can give you a real edge. For you, our learner, hopefully, this knowledge helps you ask the right questions, whether you're the inventor or advising one, to make sure those innovations get the strongest protection possible wherever they started. Thanks for diving deep with us.
My pleasure.
And a special thank you, as always, to Mike Shepard, the creative director who organized this entire audio series. Just a reminder, this deep dive into the MPEP is for general educational and informational purposes. It's not legal advice, and definitely not a substitute for formal instruction. For the official word, always consult the official MPEP itself, a qualified instructor, or of course a registered patent practitioner.